perpetrator in the conspiracy. Notwithstanding my participating, they have sworn falsely for the purpose of taking my life. They would not even inform the court how I gave information of money being on board. They had the biggest part of the money, and have sworn falsely. I have said enough. I will say no more. By the court: the court will wait patiently and hear all you have to say. If you have anything further to add, proceed. Wansley: Then proceeding. In the first place, I was the first to ship on board the Vineyard at New Orleans. I knew nobody. I saw the money come on board. The judge that first examined me did not take my deposition down correctly. When talking with the crew on board, said the brig was an old craft, and when we arrived at Philadelphia, we all agreed to leave her. It was mentioned to me that there was plenty of money on board. Henry Atwell said, "Let's have it." I knew no more of this for some days. Atwell came to me again and asked, "What think you of taking the money?" I thought it was a joke, and paid no attention to it. The next day he said they had determined to take the brig and money, and that they were the strongest party, and would murder the officers, and he that informed should suffer with them. I knew Church in Boston, and in a joke asked him how it was made up in the ship's company. His reply, that it was he and Dawes. There was no arms on board as was ascertained. The conspiracy was known to the whole company, and had I informed, my life would have been taken, and though I knew if I was found out my life would be taken by law, which is the same thing, so I did not inform. I have committed murder, and I know I must die for it. By the court: If you wish to add anything further, you will still be heard. Wansley: No, sir, I believe I have said enough. The district attorney rose and moved for judgment on Gibbs, in the same manner as in the case of Wansley, and the court having addressed Gibbs in similar terms, concluded by asking what he had to say why the sentence of the law should not now be passed upon him. Charles Gibbs said, I wish to state to the court how far I am guilty and how far I am innocent in this transaction. When I left New Orleans I was a stranger to all on board, except Dawes and Church. It was off Tortugas that Atwell first told me there was money on board, and proposed to me to take possession of the brig. I refused at that time. The conspiracy was talked of for some days, and at last I agreed that I would join. Brownrigg, Dawes, Church, and the whole agreed that they would. A few days after, however, having thought of the affair, I mentioned to Atwell what a dreadful thing it was to take a man's life, and commit piracy, and recommended him to abolish their plan. Atwell and Dawes remonstrated with me. I told Atwell that if ever he would speak of the subject again, I would break his nose. Had I kept to my resolution, I would not have been brought here to receive my sentence. It was 3 days afterwards that the murder was committed. Brownrigg agreed to call the captain from the cabin, and this man, pointing to Wansley, agreed to strike the first blow. The captain was struck and I suppose killed, and I lent a hand to throw him overboard. But for the murder of the mate, of which I have been found guilty, I am innocent. I had nothing to do with that. The mate was murdered by Dawes and Church. That I am innocent of this I commit my soul to that God who will judge all flesh, who will judge all murderers and false swearers, and the wicked who deprive the innocent of his right. I have nothing more to say. By the court: Thomas J. Wansley and Charles Gibbs, the court has listened to you patiently and attentively, and although you have said something in your own behalf, yet the court has heard nothing to affect the deepest and most painful duty that he who presides over a public tribunal has to perform. You, Thomas J. Wansley, conceive that a different measure of justice has been meted out to you because of your color. Look back upon your whole course of life. Think of the laws under which you have lived, and you will find that to white or black, to free or bond, there is no ground for your allegations, that they are not supported by truth or justice. Admit that Browning and Dawes have sworn falsely. Admit that Dawes was concerned with you. Admit that Brownrigg is not innocent. Admit in relation to both that they are guilty. The whole evidence has proved beyond a doubt that you are guilty. And your own words admit that you were an active agent in perpetrating this horrid crime. 2 fellow beings who confided in you, and in their perilous voyage called in your assistance, yet you, without reason or provocation, have maliciously taken their lives. If, peradventure, there was the slightest foundation for a doubt of your guilt in the mind of the court, judgment would be arrested, but there is none, and it now remains to the court to pronounce the most painful duty that devolves upon a civil magistrate. The court is persuaded of your guilt. It can form no other opinion. Testimony has been heard before the court and jury. From that we must form our opinion. We must proceed upon testimony, ascertain facts by evidence of witnesses, on which we must inquire, judge, and determine as to guilt or innocence by that evidence alone. You have been found guilty. You now stand for the last time before an earthly tribunal, and by your own acknowledgments the sentence of the law falls just on your heads. When men in ordinary cases come under the penalty of the law, there is generally some palliative, something to warm the sympathy of the court and jury. Men may be led astray, and under the influence of passion have acted under some long smothered resentment, suddenly awakened by the force of circumstances, depriving him of reason, and then they may take the life of a fellow being. Killing, under that kind of excitement, might possibly awaken some sympathy, but that was not your case. You had no provocation. What offence had Thornby or Roberts committed against you? They entrusted themselves with you, as able and trustworthy citizens, confiding implicitly in you. No one act of theirs, after a full examination, appears to have been offensive to you. Yet for the purpose of securing the money, you coolly determined to take their lives. You slept and deliberated over the act. You were tempted on, and yielded. You entered into the conspiracy, with cool and determined calculation, to deprive two human beings of their lives, and it was done. You, Charles Gibbs, have said that you are not guilty of the murder of Roberts. But were you not there, strongly instigating the murderers on, and without stretching out a hand to save him? It is murder as much to stand by and encourage the deed, as to stab with a knife, strike with a hatchet, or shoot with a pistol. It is not only murder in law, but in your own feelings and in your own conscience. Notwithstanding all this, I cannot believe that your feelings are so callous, so wholly callous, that your own minds do not melt when you look back upon the unprovoked deeds of yourselves and those confederated with you. You are American citizens. This country affords means of instruction to all. Your appearance and your remarks have added evidence that you are more than ordinarily intelligent, that your education has enabled you to participate in the advantages of information open to all classes. The court will believe that when you were young you looked with strong aversion on the course of life of the wicked. In early life, in boyhood, when you heard of the conduct of men who engaged in robbery, nay more, when you heard of cold-blooded murder, how you must have shrunk from the recital. Yet now, after having participated in the advantages of education, after having arrived at full maturity, you stand here as robbers and murderers. It is a perilous employment of life that you have followed. In this way of life the most enormous crimes that man can commit are murder and piracy. With what detestation would you in early life have looked upon the man who would have raised his hand against his officer or committed piracy? Yet now you both stand here murderers and pirates, tried and found guilty. You, Wansley, of the murder of your captain, and you, Gibbs, of the murder of your mate. The evidence has convicted you of rising in mutiny against the master of the vessel. For that alone the law is death. Of murder and robbery on the high seas, for that crime the law adjudges death. Of destroying the vessel and embezzling the cargo, even for scuttling and burning the vessel alone the law is death. Yet of all these the evidence has convicted you, and it only remains now for the court to pass the sentence of the law. It is that you, Thomas J. Wansley, and Charles Gibbs, be taken hence to the place of confinement, there to remain in close custody, that thence you be taken to the place of execution, and on the 22nd April next, between the hours of 10 and 4 o'clock, you both be publicly hanged by the neck until you are dead, and that your bodies be given to the College of Physicians and Surgeons for dissection. The court added, that the only thing discretionary with it was the time of execution. It might have been ordered that you should instantly have been taken from the stand to the scaffold, but the sentence has been deferred to as distant a period as prudent, 6 weeks. But this time has not been granted for the purpose of giving you any hope for pardon or commutation of the sentence. Just as sure as you live till the 22nd of April, as surely you will suffer death. Therefore indulge not a hope that this sentence will be changed. The court then spoke of the terror in all men of death, how they cling to life whether in youth, manhood, or old age. What an awful thing it is to die. How in the perils of the sea, when rocks or storms threaten the loss of the vessel, and the lives of all on board,
how the crew will labor night and day in the hope of escaping.